Thank you very much. Thank you, everybody, and welcome back to this final part of this session. As I told you in the beginning, I'm pretty sure nobody's interested in to know what I have to say. That's why instead I will have some questions to our speakers. And I would like to start with the general, all questions, around 3 questions, are directed to all 3 speakers. And I will start actually, my first question is I was inspired by the conclusions, the last part of Professor Wright's speech, and where he introduced the concept of justice. Therefore, I have a question to all our 3 honorable speakers. Do you think that the concept of justice can be used as a tool to set the law back as the center of regulation? I was thinking, for example, Anna, you were speaking about somehow a more just idea of ownership, or Max, you were implicitly in your speech suggesting how the use of business practices is the legal relevance of the business practices somehow contributes to a more just system because it takes into consideration the addressees of the regulation. So my first question is then, can the concept of justice, as Richard Wright was speaking before, consider it as the tool that enabled the law to become again the center of regulation? And connected to this, also maybe a preliminary question. It is just to have law as a primary tool of regulation. I mean, because in the end of the day, and here is a more provocative statement, law is the product of few directed to regulate the behaviors of many. Is it then just using the tool of law? Does it create injustice maybe because you apply the idea of the few to the behaviors of many? Who wants to? Anna, would you like to start?
Yeah.
Thank you.
So yes, I think the invitation to think about justice is a really important one, and I think Richard and I have definitely provided 2 robust but ultimately different notions of justice, right? I think both Richard and I are reacting to liberal justice, to a liberal justice that presupposes a social order where what count the actors are the individual and the state, and where justice means negative freedom, where justice means a minimum of positive freedom, and where justice means personhood, autonomy, and meaningful autonomy and personhood. We've both moved away from that. Richard proposed an Aristotelian idea focused on human flourishing and capabilities. Well, he didn't mention capabilities, but I would rephrase it as Amartya Sen and Martha Nussbaum have as the fundamental capabilities that are necessary for human flourishing. I think I went one step further with the idea of democratic socialism, and the step forward is really participation, right? It's not only distributive equity, but is democratic participation. Democratic participation is empowering, meaningful and democratic communities that empower individuals. So yes, access and participation, and of course, I think an aspect that has been sort of marginal to the or relatively marginal to the Aristotelian notion of justice as human flourishing that Richard was proposing, I think, is sustainability. And that's something that, of course, I mean, where Scandinavian and Northern legal culture, especially historical, but most importantly in recent years, has played a leading role. So, yes, I think definitely we all believe that some form of justice needs to be at the center of this new framework, transformative framework, and I think we propose slightly different ideas of justice.
Yes, and do you think, as a second question, do you think law is the proper tool to create justice?
Well,
I don't want to sound too much as Duncan Kennedy. That
right.
yes, I know, but because law is actually an oppressive instrument, it's an authoritative instrument per definition.
Right. I'm more focused on ways of structuring
Okay.
social relations that are not necessarily, some are in part legally based, but not
Okay.
exclusively. Yeah.
Yes. Thank you, Max.
Okay, I was thinking about, thank you for the question. The idea of justice when it comes to, for instance, topic of my speech, business practices, is of course there is some perhaps diluted meaning of the word democratic aspect of it, since it's the acts and ideas of the directly concerned parties that are channeled that attain some kind of a level of law, and therefore perhaps considered as being legitimate and therefore just. But then I don't know. Then on the other hand, I also see that there's a danger there, because it's quite hard to pinpoint for an external observer when a rule is established. Suddenly something happened, and whoops, we should have taken a right turn a couple of decades ago, and suddenly we ended up where we did not want to be, and that's an aspect that I see that the concept of justice might perhaps be threatened by or at least the common concept of justice might be perhaps challenged or threatened by an overly reliance on customs and such business practices, for instance. So I see a few problems there when it comes to the concept of justice.
Thank you, Max. Then the word to Richard, who started actually all this discussion, because you were the first one to introduce in the entire conference the idea of justice. That's what struck me. Actually, could be a very good subject. So.
Yes, I mean, I actually, I think I completely agree with Anna. In fact, I long had an interest in democratic socialism, you might call it, participatory, like in Yugoslavia, earlier and so forth. And I think that, yes, that what's often ignored, I think, in modern liberal society is both the needs distributive justice side of justice, as well as the participatory side. And I think I mentioned that courts obviously can be involved and are involved as a constitutional matter in enforcing a lot of participatory right to vote, speech, freedom, assembly, travel, and so forth, things that are very important in terms of human flourishing of individuals and society as a whole. And I think that along with Max, I'm a little bit leery of putting too much reliance on custom I mean, even though I focused on community standards and so forth, that if you look at custom, going back to the T.J. Hooper case, which I had learned in hand, is that custom business practices are often self-interested, in terms of a practice of a particular industry. They will tend to do the minimum required in terms of safety rather than maybe what really is required as a matter of pure taking into account the interest of all those that they are affecting through their activity. So, but I think that, it's not a matter of can we use law to achieve justice. I think that's the whole, and then going back to Aristotle and Kant and the Federalist Papers, that's the whole point of law. The law exists. The purpose of law is to achieve justice, is to try and, implement people's human flourishing in this proper sphere of law, which is not trying to regulate virtue or personal morality, but in terms of trying to provide the resources people need to go about their lives in a fair and equal flourishing sort of way, and to provide proper protection of the resources they do have that are affected by the activities of others. So that's distributive justice and interactive justice. And I, by the way, I meant to say, I said I was going to say in my talk, and I forgot to come back to it, that it's not as if private law is associated purely with interactive justice and public law purely with distributive justice. Again, public law often has a lot to say about interactive justice. It's often, does a predominant role in trying to assure through environmental regulations and so forth, through work practice regulations, to try and assure the personal and property safety of individuals in society, as a general sort of platform. And I think that also, I think, as Donald Nolan pointed out, that regulations are important, even though I focused on, the community standards and so forth. Regulations are important in terms of, not being conclusive, but in terms of providing, a beginning or a benchmark point for a proper assessment of reasonable care. As he says, we wouldn't want to have a speed limit based on what you think is reasonable. You need to kind of set a limit that seems to be a proper limit in light of your various purposes, safety, energy, conservation, whatever. But then, recognize that in particular circumstance, there may be reasons to go faster or slower. And the same thing in terms of for example, nuisance law. Nuisance law, like property law in eminent domain, the same thing in nuisance law in terms of when it says we're going to allow you to go ahead and engage in this practice, which is producing spillover effects to your neighbors, in light of very important public interests that are important for all of us. But there's no reason that this particular neighbor should be the only one to bear the burden of this public benefit. And you should compensate them, for the harm to them, to make sure that, that they're not the only ones bearing the burden, that they're enjoying the benefits, but also that the burden is shifted through taxation or prices or whatever to all those who are benefiting from this public benefit. So we do have, in nuisance law itself, we have this idea of, we take into account distributive concerns in implementing nuisance law when we refuse to grant an injunction, instead limit you to compensation. The same thing, we find in property law. Much of property law is based on, restraints and restrictions and so forth, intended to try and preserve, access to property by all. We don't want to have feudal, long-standing, building up of property rights in certain families and individuals. We want to have property, available for access to others. We want to limit restrictions in terms of servitudes and restraints and so forth, insofar as those make it more difficult for others to have access to and use property. In fact, the United States Supreme Court in the Hawaii case, upheld the taking of land from landholders that owned the great bulk of property in Hawaii to redistribute it, in smaller packets to other members of in society. So um, you know, uh, private law, property law, tort law, whatever sort of thing. It's often aimed mainly at interactive justice, but it also takes into account distributive concerns. And I think that basically that's what law should be doing. It should be focusing on. And of course, there's also procedural justice of making sure that people, are treated properly as autonomous individuals, and self-determining individuals in terms of access to courts and what there's done in courts. In public law, people often there's a big distinction, I think, in Europe and academics anyway, between tort law and criminal law. People usually, teach obligations on one side and don't teach criminal law. In the U.S., it's much more common to teach both because they both are based on the same sort of really basic norms. But tort law focuses on wrongs to particular individuals. Criminal law focuses on wrongs to society as a whole, and is enforced through public agencies for the wrong to society as a whole. Or even if it's enforced sometimes by individuals, it's on behalf of the society as a whole, as distinct from any individual harm to them. And we see, procedural practices in a lot of European jurisdictions more or less implemented that don't exist in the U.S. of allowing, tort claims to be attached to criminal law claims, if both of them arise in the same situation. What often is not recognized, I think, in European law, except in certain countries like Sweden, for example, is that that private law and public law, tort law and criminal law really are distinct in terms of what focus on the wrong to the individual as a whole in criminal law, which is based on really being an outlaw, putting yourself deliberately outside the law, refusing to follow the rules of social order. And before we kind of in criminal law are willing to kind of proclaim you to be that sort of individual, we set very high standards of proof, beyond a reasonable doubt, virtual certainty, and so forth. Whereas in the common law, it's very clear if we turn to tort law, we don't need to have the standard that high. It should not be merely a probability that this happened, but it should be, all we require is not beyond a reasonable doubt, or maybe even clear and convincing, but simply a minimal belief. There has to be a belief this is what actually happened. But it could be just a minimal belief, a bare threshold, which allows us to say, you're not guilty of the crime, O.J. Simpson, but you are guilty of the tort. And that's recognized, I think, for example, in Sweden, some cases went to the European Court of Justice saying you can have tort liability even though you've denied criminal liability, as long as the tort claim is not implicitly saying you're a criminal. And a lot of other European countries, through their procedural rules, take the position that if you weren't convicted criminally, you can't be held liable in tort, which I think is wrong and misunderstands the different bases of those two areas of law. On the other hand, we have in the U.S., not to be too long, I apologize, we have in the U.S. a very incorrect perception of punitive damages, which is kind of based more on a deterrence sort of notion, which the only proper basis for punitive damages, as it's recognized in a lot of European jurisdictions underneath, aggravation damages or satisfaction damages, is the insult and indignity to the individual. So punitive damages in tort should be limited to situations where there really has been a deliberate disregard of the rights of the person involved as an individual, and should not be used simply as a backstop to criminal law.
Thank you. Thank you very much. I think we have a follow-up questions from the...
No, we have a question from the online chat, and I read it. I would like to ask the panel, especially Anna, how a more inclusive notion of property is compatible with the current mode of de facto technological exclusion. In other words, while AI and the take it or leave it logic is perfectly compatible with exclusion, it seems to me that it is at odds with more humane values such as those we are advocating as lawyers.
Yes, that is exactly why, and it's a very good question, and that is exactly why we need a radical reconceptualization that is not only analytical, but is most importantly normative and programmatic, and that's why we need to recenter a different notion of the desirable, a post-capitalist, normatively and programmatically desirable social order. That's why I proposed one idea, democratic socialist. But I think, the real point that this question from the remote audience raises is that, as Wolfgang Streeck so powerfully writes in this recent article on the New Left Review, we have to go beyond liberalism, right? There's no revamping US liberalism, correcting exposed US liberalism, and there's no revamping traditional social democracy, I think. We really need a good dose of creativity that is not only legal and analytical, but is also in terms of normative vision.
Thank you very much.
But the question was to the whole panel, so if the others want to address it.
Well, I was thinking about what Alexander Helgart referred to yesterday, the idea that in some cases when someone is, where an actor dominates a specific field of life, that suddenly we have to reject, or at least leave the liberal idea of freedom of contract, for instance. In that way, the exclusion by means of digital instruments, etc., is something that we have to reconsider, namely where to draw the line of what's included and what's excluded.
So maybe Richard?
Yes.
Yeah, could you repeat the question for me, please?
Sure. I would ask the panel how a more inclusive notion of property is compatible with the current mode of de facto technological exclusion. In other words, while AI and the take it or leave it logic is perfectly compatible with exclusion, it seems to me that it is at odds with more humane values, such as those that we are advocating as lawyers. So essentially, it's linking the idea of take it or leave it to the emergence of AI as a social phenomenon or as a social tool, however you would like to describe it, and asking if a more inclusive notion of property is compatible with this social phenomenon, the rise of smart solutions of some sorts.
I'm not sure about the more inclusive notion of property, but I do think that the take it or leave it, click things that are prevalent now on the internet are quite problematic, and that there needs to be some means implemented of which I presume is going to have to be through law of providing a more just allocation of rights and risk and benefits, in these sort of things. I mean, of course, it's become even worse in the U.S. because the U.S. Supreme Court, being quite business oriented in recent years, has upheld, it actually kind of held contrary, well, maybe not unconstitutional, but contrary to the Federal Arbitration Act. California's, for example, making illegal binding arbitration, once the Supreme Court upheld the fact that that binding arbitration is possible, in the U.S. anyway, we've all been flooded by banks and finance companies and credit card companies with these, take it or leave it things. You agree to binding arbitration or you don't get our business. So I think those are very bad, undemocratic, unjust sort of moves. And I think that there has to be a process available, in the arbitration sphere as it is in courts. There has to be available in the arbitration sphere and on the internet. Some means for individuals to be able to kind of avoid this take it or leave it and have a fairer balance of interest between them and the person that's controlling this particular property.
Thank you very much. And connected to this question, actually, I have to tell you that to all of you that when we came with the idea that is Filippo, Kelly, and I, we came the idea what should be this conference about. That is, we came with the idea about this law at the center or at the periphery of regulation, question mark. We thought immediately to two phenomena that occur among the others, that the two phenomena that has caused this somehow questioning the positioning of the law. Two phenomena that are somehow have gone through during these 3 days went undetected. And the first one is the phenomenon of digitalization, we all know that we live half of our life on the internet. Just to give you an example, there is here 20 people in the room, but I know there is 200 of our colleagues that look at us through the cyberspace. So just to give you an idea how digitalization is important. Then my idea is how digitalization affect the topic you have talked about. I give you 3 examples. For example, Max, you were speaking a lot by facts, yes? But then, how can you still use the concept of facts when you go into the cyberspace? I'm thinking, for example, about the fact of mining in order to produce Bitcoin. Is really fact the correct? Can you use it in a legal context, this one? For example, also with you, Anna, you were speaking about property a lot, but as you know better than me, all our colleagues intellectually, property law, is it really property? Can you speak really a property of the web or in the web, really? Is it really property, a concept that is still valid? And to conclude with you, Richard, you were stressing very much in the beginning of your speech the divide between private law and public law, but you know better than me, does it still valid when you have to do with let's say, conglomerate as, for example, Facebook, that they don't even have their own headquarters in some specific space. They tend to operate as a private actors, but also taking over many of the public law roles and also, as I said, often when you go into the cyberspace, it's even difficult to locate where you locate. So is it still, this divide between private law and public law valid even when we talk about the cyberspace where, as I told you, we live half of our lives and often we do half of our legal business there? My question to all 3, can we work with the traditional concepts that we have used also when we operate in a cyberspace? Is it not maybe the time to think of, at least maybe, is there a possibility of a parallel legal discourse? One for the real world and one for the cyber world?
I'm happy to start with property. So I think, yes, we can still use the concept of property as inherently relational, as competitive relations among individuals around valuable resources. That applies very well to the cyberspace as well. I also think that historically, property has never been physicalist. There has always been a very clear, intangible dimension that I think goes back to Roman law. Clearly, Blackstone, who sort of fabricated this idea of absolute dominion over a physical thing, was very well aware that intangible property was a big part, even in 18th century England, of property law. So yes, I think the concept is still a valid one. I'm not particularly well versed in this question, but there's a big, I teach first year property in the US, and there are these cases that we discuss and questions that we discuss with with my students, for example, what are the limits of the right to exclude anti-discrimination, for example, on the metaverse, right? Take a case like Second Life, which is a game where you effectively have another existence in Second Life. Does the right to exclude, do the limits of the right to exclude that we apply to like physical public accommodations, restaurants or hotels, or do they apply to Second Life? Students get very excited about this question for very good reasons. I think we have the tools to solve these questions. I don't think, but I haven't done any work on this. But it's a great question.
Max, thank you.
Well, I was thinking about that. In my area, I'd say that most definitely digitalization will affect it quite tangibly, because it will have very decisive effects on our social lives. I mean, if you're excluded from, say, Second Life, well, perhaps you're cut off from your friends, etc., and it might not actually be a thing if we equate facts with things. I mean, it's something else we're talking about. We're talking about digital processes, etc. But I think that what we see here is perhaps the beginning of, or perhaps we're not even the beginning, we've probably left the beginning. We're in the middle of a regulation that is dictated by technological necessities, or what is considered to be technological necessities. And these facts and practices will have will definitely have thoroughgoing effects on well, our lives, what we can do, what we're forbidden from doing, our standards of conduct, or etc. So I see that that's most relevant question. The problem is perhaps who should we leave the reins to? Should we allow the commercial actors to establish their business practices, that is, write their programs and set up their rules for joining their arenas, or should we perhaps return to the old-fashioned black letter legislator, the state or nation legislator, who then can set a different standard that lives up to other levels of care than the minimum level of justice or protection that Richard was talking about.
Thank you, Max. Richard?
Yes, I don't see any problem with treating intangible interest as property, and I think the larger issue is, again, who are we allowing to regulate these interests and access to them? And so far in the internet area, it's been pretty much allowing the commercial interest to, particular companies to regulate access and so forth, and to demand, certain terms that you have to agree to, which again, I think is improper, and legislatures should step in to, within reason, to guarantee access and not allow these sort of take it or leave it sort of things. I recall, sort of from the other end of the spectrum, people are probably may or may not be familiar with the Intel versus Hamidi case in California that involved Intel Corporation trying to bring a trespass action to prevent a disgruntled former employee from flooding its internal network with messages contrary to the company interest, and the company wanted to try and be able to kind of to stop that from happening. And I think that it was complicated in the U.S. context by the fact that in the U.S., if it's a trespass to chattel action, unlike I think in other common law countries, you have to show some actual harm, some sort of actual significant harm. in order to kind of have the action be actionable, in terms of damages. The court, kind of pretty much, got rid of the action on that basis. But I think that, there's a separate question, as there is a nuisance law well, maybe you don't, maybe you get damages, maybe you don't. But there's also the issue of injunctive relief. Can you at least stop them from continuing it? But that raises in the court, I'm sure what they were really concerned about was First Amendment access issues, access to the internet and so forth. So they said, we prefer to have the legislature come in and try and regulate this area in terms of trying to balance the access interest, the free speech and access interest with the ownership interest of Intel in terms of its own, internal server system. So I think there does have to be balancing done, but I think it has to be, again, the balancing should be done in terms of what is proper in terms of people, being able to have access to the means they need to go about meaningful in a participatory way, in the internet nowadays, as well as other aspects of socialization.
Thank you. Thank you very much, Richard. I think we have a question.
We have somebody writing a question, but it is not finished, so I can perhaps inject my own question if it's okay with you.
Go ahead.
And I have a question for Anna mainly. What you said about a reconceptualization of property reminds me remotely, but it reminds me a little bit of what Pugliatti tried to do in Italy after World War II, after the rise of the Republican Constitution, because we got in Italy Article 42 with the idea of the social function of ownership, and therefore he formulated the idea of different proprietary or different ownership regimes. And the point was essentially, let's take this monolith, which property has been until now, and let's decompose it in a sort of a prismatic way, adapt it to the different the different things that it can be applied to. And the same thing, I think, it goes in line with your very interesting idea to sort of revitalize the notion of dominium divisum, and also the attention of medieval law to material things that are needed for our lives that were at the center of the property regimes. But what is interesting, however, of these ideas is that, now I'm talking mainly about Pugliatti, they didn't really bear a lot of fruition, because in Italy the idea of social function of ownership has played some roles, but not nearly as incisive a role as Pugliatti probably imagined. And so that goes to sort of some regulatory strategies, because in my mind you are still saying, well, we should put aside liberal notions of property, we should reconceptualize property, but the notion of property is still there, however reconceptualized. What is interesting about the Swedish legal experience is that in general, but in particular at the beginning of the 20th century, property disappeared from the radar as a notion which was considered useful in private law legal analysis. So it's not something that Swedish scholars or judges use traditionally to make So the point is essentially, should we reconceptualize, or should we simply say, well, there is not one property? We should probably dispense of the notion and instead think of several different regulatory regimes which we don't collect under a very big and very cumbersome umbrella, because I think that umbrella then carries a sort of ideological load which defies the purpose of destructuring the various regimes. So, your impression of?
Filippo, this is a wonderful question. So, yes, Pugliatti is my personal hero. I've written extensively about Pugliatti's work, and I think you're absolutely right. Years ago, I wrote a piece that is titled "Property, a Bundle of Sticks or a Tree," and the image of the tree was Pugliatti's image, right? So I was contrasting the Hofeldian and post-realist idea of property as a bundle of analytically distinct entitlements, a bundle that can have different scope and different shape, to Pugliatti and just around, but the idea of the tree is Pugliatti, idea of property as a tree that has a robust trunk and many resource-specific branches. You're absolutely right in your two observations that first, the trunk of the tree was still liberal property. Absolutely. It was liberal property. It sort of conceptualized and described this idea of what is common to all the resource-specific regimes, which is use, for the autonomous use, autonomous decision-making power and how to govern and use the resource. It was still liberal property. You're also, on your second question, it wasn't that, this idea of resource-specific property ultimately didn't prove that influential. Yes, though maybe in Italy, though I think, for example, among economists and legal theorists today, Elinor Ostrom, I think it's the idea of proprietary regimes that sort of reflect the characteristics of different types of goods, of different types of resources, the focus on resource attributes. Obviously, I'm not claiming that it came directly from Pugliatti, really not claiming that, but it's an idea that keeps circulating, right? Leanne Fennell, I think, who's a law and economics scholar, has also done some very interesting work inspired by Ostrom and also focused on resources. So that, I think, it's an idea that remained vital in a way, even though obviously not a direct appropriation of Pugliatti's ideas. What should we, what is the next step? Should we reconceptualize property or abandon property altogether? Well, I'm a big fan of retaining the concept, the relational concept of property that I propose. I don't think that efforts at fully disintegrating property that we've seen in the years of critical legal studies, I honestly don't think these are fruitful. They do not allow any analytical, diagnostic, and constructive work. There's still something to the idea of property. So, thank you very much. That's a great question.
Just to make that clear, we have a question from the internet, if it's okay, Mauro?
Yes, maybe I finish with my question. I have one last question.
Sorry.
I have my last question to all the three panelists. As I said, one of the reasons why we saw this questioning the positioning of the law either at the center or periphery of the regulation, one was the digitalization, but the other was actually another phenomenon that has not been mentioned very much here, is the question of globalization. Actually, this is a provocative question that I would like to pose to you, because you all, it started also with Ugo Mattei, I must confess, because he was speaking about the West, the West law has imperialistic, but then even there the discussion was between Europe and the United States. And the same, as I've noticed, Richard Wright, you also speak about civil law, common law, that is, but actually we live in a globalized world. Well, actually the second economic power is neither US or neither Europe, it's China, and is growing, for not talking about this BRICS economy, Brazil, India. And I know many of our colleagues say, well, but in the end, China, and in this sense, I'm very sorry that we had not the possibility yesterday to listen to the wonderful lecture that was supposed to be from Mimi Zhu because of her illness. At least based on her PowerPoint, it should have been really helped. It should have given a really vital contribution, but unfortunately, when he's sick, he's sick. And yes, I wanted to ask you, why do you think do you think we still live in this dichotomic world, either US or Europe, either civil law or common law? Because let's face it, as I say, well, it's true that China, for example, is often looks to US or Europe, but then they rewrite the law. They rewrite their legal categories in their own specific terminology, in their own specific ideas. So, as I said, since we do not live only between Europe and US, and law tend to operate on a global level, isn't it maybe the case to somehow to trespass, go over this dichotomic idea, civil law, common law, or US, and start to think that we live more in a really globalized and that is polycentric world? Anna?
Yes, absolutely. And I think, so first of all, the first point I want to make in response to this is that Romanist, what I called Romanist bourgeois property, what we know as Romanist bourgeois property, was a global product. It was a concept that was crafted by liberal jurists in the metropolitan center and in the post-colonial or informal periphery of Europe in Latin America, but also in the Arab world, for example, through very specific networks of elite, professional, academic knowledge, where some actors acted as cultural mediators and facilitated this, this sort of circulation of knowledge. Mattei years ago wrote When the Wind Changed. The wind changed, and specifically when it came to certain concepts, and I'm thinking, for example, of the social function of property. Well, the most expansive notion of social function of property is a product of Latin America, is a product of Mexican jurists and the Mexican Constitution. So definitely that's one thing. And the other element that I think it's important to keep in mind is that despite being a global product of the center and the periphery, Romanist bourgeois property was a fundamental tool of imperial exploitation, of global imperial exploitation. It was used to, deprive communities of color and black people of their land. It was used to deprive them of their labor and to deprive colonial communities of color often of their lives too. So that's another, the global exploitative dimension that continues well into today. And the scope of the transformative vision of property that we discussed, yes, of course it's global. And the whole thing of governing resources in an inclusive way, well, lithium, for example, that has obvious global, an obvious global aspect in terms of the consequences and the demands for climate change, the needs of local communities, foreign investors. So yes, absolutely, you're totally right.
Thank you, Anna. Max?
Well, I was thinking about to begin with, the dichotomy U.S. or common law, civil law is perhaps even, I think that is perhaps false, because I think that the dichotomy is somehow the West versus the rest. We have everything outside of the Western legal tradition, and in that case, the problem, the issue that rises is, according to me, is that we have to perhaps see who's allowed to, if I use my perspective about business or social practices, who's allowed to be in. I mean, the participatory aspect of justice that when using social practices or customs as a source of law is that it provides a high level of legitimacy since the rules actually reflect what you, quote unquote, do. But the problem is, who is this you? Who is included in the group of participatory doers, whose ideas and practices actually matter? And I was thinking about one aspect that you mentioned here, Anna, was that how the Roman idea of property has been used in a colonial, actually to as a tool of colonialism, is that I can see the same effects, for instance, in Sweden, where the Samic population initially they had the same set of rights of property as everyone else. That is, it was divided into various levels and stratas. It was direct, indirect, utile, etc., etc., etc. But since their social practice of using landed property was extensive rather than intensive, their rights when the property the doctrines of property law in Sweden were changed in the 19th century, their rights they ended up with the right of use rather than ownership. And I mean, I'm not totally surprised, since they were an indigenous people and they tend to get the short end of the stick. But nevertheless, you see how there you see the idea of what are the effects of globalization? Whose idea of globalization matters? Whose ideas of regulation and what is considered to be the proper form, the proper practice actually counts. And I guess that. Given that we see perhaps a shift in powers globally in the near future, that we'll perhaps have another idea of property, for instance, or other ideas of justice. Most definitely, we might not like them, but there will be shifts, I guess.
Thank you, Max. Richard?
Yeah, I guess that. I had meant to say when I was talking, I thought I had said that I didn't really agree with the usual sharp distinction between common law and civil law, at least in the area of torts and contracts and even property so much. Although I think that where there is variation around the world, it's more in the area of property law than it is in tort or contract and things like that. There's, for some reason, different property regimes develop, more easily. Depending upon the culture, China, whatever sort of thing. But I've had a thought, and one of the big benefits of the Common Core program is looking to see to what extent, despite different structures of law in different societies and, in different means and supposed sources of law, to what extent is there really a difference in practice in terms of the actual substantive principles, and even in terms of who actually is kind of really developing the law. I tried to argue that although it's thought that the basic source of private law in Europe is codes and not court decisions, that actually it's in Europe as well as in civil law jurisdictions as well as in common law jurisdictions. I think the real basic developer of the body of law is the courts. They are the ones that kind of have to take these very vague general clauses and have them have some sort of meaning. So I think that if you look at the actual the actual results in particular cases, for example, in private law, I think I found this, my lifelong sort of work has been that there really isn't a big difference. It really because it all really comes down to, unless there are very strong, powerful, self-interested players, It really comes down to what people think is just, what is fair, what is proper, in terms of relationships among people. And that's pretty much the same everywhere. Now, the thing that surprised me that I started to recognize maybe about 20 years ago, when I started paying more attention to civil law, is that the major difference between common law and civil law countries is not in substantive law, it's in procedure. There are much more significant differences in terms of procedure, in terms of, loser pays versus contingent fee, in terms of allowable remedies, in terms of allowing tort claims to be attached to criminal claims, in terms of standards of proof. The really interesting area of difference, I think, between different jurisdictions is procedural and not substantive.
Thank you very much, Richard. Before to go to the Q&A from the web, is there any questions from the audience who are here not in cyber presence, they're here in real world? Okay, if there are no questions from the audience, we have, I think, a couple of questions from the remote audience.
Yes, thank you. We have a couple of questions from Ugo Mattei, actually. The first is, don't you think that what is going on today, is the return of the logic of the internet frontier, take it or leave it, among brackets, in the material life through means like green pass or the Chinese notion of point citizenship? In fact, historically, all invented notions, even the bourgeois notion of property, were experimented on the frontier first and then returned in the motherland out of increased efficiency. It is in the internet frontier that there is today the kind of tabula rasa that was possible to find in America in the 18th century. So no dual system, one for internet and one for the real world, unfortunately. And then we have, can I ask the second question as well, or do you prefer?
I think, can we answer the first question?
Yes, it seems
it's quite complex.
More humane, yes.
It's exactly, it's voluminous. Anna, would you like to answer? Or?
I totally agree with Ugo's analysis. As I said, I haven't spent much time thinking about the specifics of how the concept of property apply, like what is needed from a transformative perspective specifically for digital property. I'm not an IP scholar. But I find very powerful this idea of the frontier, and the analysis that Ugo provided in this question is a very real one. Yes, it always started from the frontier, and yes, the metaverse, let's call it, is the new frontier, and new concepts, extractive, exploitative concepts are always start from the frontier. So yes, I think Ugo is right.
Thank you, Anna. Max.
I have to think about that one.
Richard, would you like to answer?
I have nothing to add on that either.
Okay, thank you. Then we go to the second question, I think.
Final question to Anna. It seems to me that today very basic liberal ideas such as person, property, privacy, and even formal equality are under attack from big corporate agendas within the logic of emergency. Is it tactically or strategically smart to challenge them?
Strategically or?
Tactically or strategically
smart to challenge them?
Yes.
Well, I think for me at least it's a moral imperative. Then when how to do that in a strategic and tactical way, yes, that's a conversation we can have, but
because as I interpret the question, essentially, certain legal scholars, as yourself and myself to some extent, we can become, we can have some strange bedfellows, so to speak, with the big corporations who are also attacking the same notions that we are attacking, but for a very different type of purposes. That's how I interpret the question, at least.
Yeah, well, that's yes, that's a risk. Strange bedfellows are always a risk, and we've seen it in big property cases in the United States recently. The Kelo case, it's a very famous U.S. eminent domain case about the meaning of public use. And yeah, progressive property and the left ended up on the same position as libertarians, exactly because of the special value of personhood forming resources like a home. These alliances happen all the time. It's also true, though, that I think the turn towards the social in the corporate world is a very superficial one, and obviously is paying lip service and can easily be revealed for what it is. So I'm not too worried of strange bedfellows, and I'm not. And yes, I think, of course, the question of strategy is, how to do this is definitely a very important one. I think, again, Eric Colin Wright has some very interesting thoughts about the importance of strategy. But yeah.
Thank you. Thank you very much, Anna. I think we can conclude here the question Q&A part. I would like to have here on the podium Marta Infantino, Kelly Chen, and Filippo, because they will have, I think, some reports. Thank you, everybody. Thank you also to the three speakers. Wonderful presentation. Thank you. Thank you, Richard. Thank you, Anna.
Thank you, Mauro, and thank you, everyone, again.
Today, I actually want to say something in my own capacity. The capacity as a researcher, as someone who is greatly interested in comparative law. In this sense, I feel very honored to have been part of this general meeting, considering the long tradition of the Common Core project. And what I hope that we have been able to show here over these past 2 days is that what we here in Stockholm can offer, what kind of platform for academic gatherings and discussions in comparative law that we can provide here in Stockholm. And I truly hope that I will get the opportunity to welcome you all back to Stockholm as speakers and participants of conferences in the future. So thank you very much.
And I would like to add once more my personal thank you, and thank you also of the organizers, the other organizers, to all of you who were here, all of you followed online, and all of you actually who made this whole event possible, in particular Sarah Larsson, Sarah Kolsten, Edda Brinkert, the technical staff, and so on. I will not mention everybody once again, but you know who you are. So this closing session is, as usual, dedicated to summarizing what the activities of the working group that took place yesterday, and in some cases even this morning. And we are only two here because Aurelia, as we know, couldn't be here, but she was so gracious as to send me some notes, which I will try to summarize by reading them from my phone. I hope it's not too disturbing that I do that. I mean, that I read from my phone. It's not my personal emails that I'm checking right now, but it's the notes from Aurelia. And she has only very positive things to report. Aurelia, chair of the contract group. There are a few projects which are either well underway or that have restarted in a very promising way. The first one is the third-party rights in contract law, and things seems to be going very well on that front. 13 country reports delivered. They have a final chapter as well. So they are essentially starting to closing in on the finish line quite quickly. Then we have the project on contractual remedies by Paula Girker, Beate Excel, and others. They seems to also to be on the final stage of preparing to close the project, which I think is just wonderful. And then we have the project on limitation and prescription. And this has been a project which was started apparently sorry, I'm reading the notes here. No, sorry, they are looking for a co-editor in the common law. So, and the other editor is then Francesco Astone from Foggia. So if anybody thinks it's interesting to get involved in a project about limitation and prescription in the realm of contracts, so please contact Francesco Astone, and they are looking for a co-editor from a common law jurisdiction. So contact then either Astone directly or through us. I think that will be wonderful. And then we have the projects on contracts in the sharing economy. And there we have a questionnaire which has been revised. So they are at the stage of working on the questionnaire. There is a project on smart contracts in European contract law. This project is an idea from December 2019. David Zammit, who is one of the editors, told that in December 2019 they had funding from Malta for legal research on smart contracts, and now an editorial team has been formed. So I think that's also a good sign of progress. And finally, on the front of contracts, we have the project about ascertaining the content of the contract, incorporation, gap filling, and implied terms. The project was, the idea was launched in 2018, and the editors have, at this point, a rough first draft questionnaire. That was my probably extremely insufficient summary of a pretty large amount of notes sent to me by Aurelia. And if somebody from the contract group wants to correct some major mistakes that I made, please feel free to do so. I will now go into the group that I was chairing myself, which is the property group. And there we have also a lot of good news to report. We have 4 projects which are essentially landing or has landed. We have the project they're edited by Björn Hopes and Ernst Marais on the acquisition of immovables through long-term use, which has been published. It is now a printed volume, and in fact this printed volume will be presented here in Stockholm at 3 p.m. today at the Stockholm Center for Commercial Law. So those of you who may be interested can absolutely join us there for a little celebratory round and some insights in the acquisition of immovables through long-term use. And we had a very fun time today celebrating online with all the reporters. I think that was wonderful. Then we have the BIP, as I call it, but Boundaries of Intellectual Property, edited by Christine Gott and others, who after a very long gestation has finally reached the finish line and is actually in the process of being published by Intersensia. And I think they have done a wonderful job, and it will be a source of great insights on the topic of the digital realm and the law, and among other things. And I think it will be a very interesting book to read. Then I would like to come with some good update on a project in which I'm personally involved as an editor that also had a pretty problematic ride, mostly due to, I think, the nature of the topic, which is, and the title now adopted by us is Property Meeting the Challenge of the Commons. So the commons are a pretty complicated notion. It's not a notion that most legal systems recognize as such. So it was not easy to find reporters willing to take on a very broad spectrum of different legal fields, which are necessary to write a report in a good way. But it was the idea of Ugo Mattei to move the project to the International Academy of Comparative Law in order to try to recruit a little bit more reporters. So the project is formally now placed there and will be published by Springer. But that idea proved quite fruitful because we actually found a good group of reporters. It took some time for them to deliver, for all of them to deliver at least. And now everything has been sent to Springer. So we are in the process of printing it. And of course, I'll keep everybody involved updated about how the process is going. And finally, we have an update from Michael Milo and Nettie Miemi and Nicholas Sparks about the project on residential immovables. And the project, in my mind, is going pretty well because they have 8 reports delivered. They told us yesterday that the reports are of a very good quality. They are still waiting for a few reports to be delivered. So if any of you here or online are among those reporters who haven't delivered yet, please do so. You would make a lot of people happy. And the only not negative, but notation that I have to do is that we don't have any new projects emerging. But that's not so strange, I think, because we have so many projects that are now in the landing phase, and we'll probably have to finish those before energies are coming up for any new projects. But if any of you has any idea that you want to discuss, please feel free to put them forward at the next occasion. Okay, I'm now leaving the scene to Marta Infantino. Thank you very much.
So this is the update from the tort law part. We had a very productive session, hybrid, yesterday morning. And we have 3 projects that are ongoing. You probably heard already of them in the previous Common Core meetings. One is the Products Liability Project, which is led by Monica Jodzon from Transylvanian University and by Markus Pilgerstorfer from a Londonese law firm. And they received already almost all the reports. They are planning in the next month to ask for updates because quite a long time passed since the first reports were delivered. And then they seem to be truly committed to push forward that project to the end. I hope this will become a reality. Then we have the project led by Richard Wright from Chicago Kent, by Miguel Martin Casals from Girona University, and by Piotr Maknikowski from Wrocław University. And that is about standard on reasonable conduct. That project too suffered a little bit from the pandemic, but the editors are now fully committed to work on finalizing the reports that are already in and providing the comparative comments and then go through publication. So this is in a very good health, that project. And in a very good health is also the third ongoing project, which is the one on mass damages, led by Rianka Rinaut and Thomas Arons from the Utrecht University. They have almost all national reports. They discussed reports with reporters both yesterday and this morning because they are now in the process of making national cross comparisons. So these two should maybe see the light before the end of 2022 or more likely in 2023. So these are the projects that are already ongoing with rapporteurs there, with reports completed, etc. We also have one project that was already mentioned in the past but still has to really kick off. We'll probably do that in April, so very, very soon, which is the Quantum project, which I like it very much because it looks like physics or James Bond, but actually it's about assessment of damages, which is going to be led by Christophe Kezelan-Brunaz from the Université de la Savoie. Okay, this is probably not accurate, but from France, and Eleni Zervogianni from Thessaloniki University in Greece. Yesterday we got a substantial expressions of interest by the people who were present either in person or online in the meeting, and so we got many candidatures to act as national rapporteurs. So I think there is a strong interest in that project, and I'm pretty confident that it will be a very successful one. But if anyone is willing to act as a national rapporteur for that project, just email me or Christophe or Eleni, and then we will keep you updated with what happens there. We also discussed about a possible new and both old idea. Why new and old? Well, many people yesterday claimed that recent developments suggest a new project on tort law and the ecology, which I fully agree. The only problem is that the Common Core published in 2008 a book on environmental liability and ecological damage. So we would need probably to frame it, to package it in a way that makes clear that, I mean, we are not just updating what has already been done, but we are, trying to explore new frontiers. And we also got an expression for a potential editor of that project. The expression came from Matteo Fermeglia from Hasselt University in Belgium. But feel free, whoever is interested, either as a possible general editor or as a rapporteur, to participate in that project, which we might call generally tort law and the ecology. Then we will need to frame it better. Once again, feel free to email me and I will put in contact with the relevant people. And the same applies to whoever has any idea on the tort law section. That would be most welcome. So that's it, and thank you very much.
Okay, so that is it, folks, as they used to say. And we've had I think, 2 wonderful days together. We've encountered and confronted interesting ideas. We have engaged in rational discourse, which once again I think is a very important thing to do in this time and age in particular. We've met new people, at least I have, and now we have lunch in 8 minutes to enjoy together. And I thank you all, reminding you once again of the book presentation 3 o'clock at the Stockholm Center for Commercial Law, where you are absolutely welcome. Thank you very much.